Welcome to Old Mutuals on the Money Show. I think today it's going to be an interesting session because we're going to be talking about a subject that a lot of people always talk about. You hear people say, yeah, you must create generational wealth. Okay, let's get to the detail around what does this mean. So today we're joined by Yolanda. I think many of you have seen her on your socials. I mean, she's been educating us on the laws in relation to your wealth, in relation to customary marriage, trust, and related topics. So today, let's learn. Yolanda, how are you?
Good, how are you, John?
I'm well. I want us to start with the credentials. You know, sometimes there are a lot of people who talk legal stuff on our socials, but they're not necessarily lawyers.
Mm-hmm.
So maybe let's start there and establish your credentials. I mean, where you've been and academically and all that. Yeah.
Okay. So I'm a graduate of the University of the Western Cape.
Okay.
I'm an admitted attorney, currently practicing in Johannesburg, South Africa.
Okay.
I actually have my own law firm. I think we've been open since 2022.
Yeah.
So yeah, we've been in this industry a couple of years now.
Yeah.
So we mainly specialize, as you know, wealth protection.
Yeah.
And many other things, but that's our main aspect of the law firm. So that's me in a nutshell.
You know, when you talk about wealth protection and laws around it, I mean, this is one of my favorite topics because I was saying to a friend earlier to say, actually, I just think this thing of ownership is overrated. But if you look at what is available in our law, actually, you can live in your dream mansion, you can drive your dream car, you don't have to own anything. For example, if something is in a trust, because then you're still a beneficiary there and you are protected, nobody can touch that. Why do you think a lot of our people are not familiar with these things? And, you know, because we have this obsession that I must own this house and that house. What's your view on that?
You know, John, I think it's a lack of education, right? What we know is that we just need to get a job, be able to afford possibly some form of loan to acquire a certain property or a car, then that's it. There's no exposure about the other options that are available, i.e. something such as a trust. But even though there's no exposure, people have always had this desire that whatever I own, can it not also be benefited by my children, my family, etc.? But nobody has ever tapped into, or let's say not a lot of us tap into trying to understand, are there opportunities for us to do this? How do we do it? And so at the end of the day, most of the time we end up just owning these properties until death. And we know what happens after death. The estates have to be administered because of these properties that we own. So it's a lack of education, I'd say. So nowadays the exposure is there. People are looking into it. So you can see that they're shifting a bit. So now people are no longer too obsessed about personal ownership. Now they're looking into things like your generational wealth. Let it not benefit me alone. Let it also benefit other people. Right? So yeah, I think that's what I picked up.
There's a reason I started there, even though I said we're gonna talk about generational wealth. But I mean this obsession about ownership. Yes, it sounds good. It sounds great. But there are other implications with owning property in your name, because when you die, okay, if you have a will, at least you were telling us where the assets need to go or what needs to be distributed and how, provided there's clarity. But then, of course, there are other instances where you may be owning properties. These properties may be in your name, but if you don't have a will, then you must go through the master of the high court, then there must be an executor, they must wind up the estate. It can be a lengthy process. And meanwhile, your cash in the bank is also frozen. During that period, you've got children that need to go to school. Sometimes when there's a dispute in the family, the money is still held up in those places, and to the extent that your bond still needs to be paid. They need to buy electricity, they need to eat and all that. It just becomes a mess whereas if it was sitting in a different instrument, nothing should be interrupted. If you are a beneficiary of a trust, for example, your comments on that?
Definitely. You see, personal ownership comes with a lot of burdens. Yeah, right now as you're alive, you like the amount of control that you have.
Yeah.
But then it comes with a lot of disadvantages, like you mentioned, i.e., we've got the administration that has to happen after your death. Moving those properties out of your estate, it comes at a cost.
Yes.
Whereas if you had it in this entity and you were benefiting from it, this move would not be necessary. Sometimes you find that it has to move from one grandparent to another, to the children. That's a lot of money.
Yes.
That's why you'd find that in certain houses or family homes, the property is still owned by the great grandparent. And nowadays, that's not a good idea. You've got bonds that need to be paid for, right? Some people don't have protection or money is available that can settle this. That's an issue because that puts that property at jeopardy. There's no money to take care of the administration. You're going to sell that property. So which means that you're compromising the home of your family.
That's right.
So personal ownership, Jay, is just overrated. Also, any other debt. Let's say you've got a house worth 1 million.
Yes.
And you're leaving a debt of 100,000. Possibility is that if there's no money in that estate of yours, that personal ownership, that property, it's gone. It has to be sold. So it defeats the purpose of you creating some form of protection. So I think it's about time that people start looking into these other avenues so that they can protect their assets. Otherwise, in this day and age, we are really risking if we're just honed in into personal ownership.
So this is the part that people don't understand. A lot of people don't understand that even if you have an estate, you have a bond, you have 1 or 2 cars and you still owe in the bank. And yes, you've written a will that you want your two children to inherit your 2 cars. You want the property which is bonded to belong to maybe one of the children or whoever you decide to bequeath it to. Now, the issue comes where you die while you're still owing your creditors. You're still owing the bank. The bank, because it's a secured debt, the bank is entitled to repossess and sell and things like that. But the role of, for example, a life cover, which does not form part of the estate, because people think if you've got a life cover, then it's part of the estate. But when there's a beneficiary, those things can be settled and then it can be distributed. But as long as you're still owing the bank, how do you expect those properties to be distributed to whoever you've nominated as beneficiaries?
So the life policy aspect, very important. If you're someone who has such debts as properties, you're still owing the bank for that, or you have, let's say, a vehicle. In particular, I always say to people, this is not something that's cast in stone. You need to have your own plan here. For example, with this issue of a life policy, very instrumental, yes, but then often we will have our own beneficiaries there.
Yes.
Got my son. It's written there. Now, is my son going to have this feeling of, I need to take care of these debts? These were mom's things. I'm trying to save them. So you are now also, even though you have a life policy, putting your property at jeopardy because you're trusting and hoping that child is going to take care of that debt. So once you have an estate plan, you get to look into these things and determine whether or not you should maybe redirect this life policy. Can it just not go directly to the bank? Let it settle the property. Then whatever is left, the shortfall, then you can give it, or rather what's left in the life policy, then give it to my son. That way you're guaranteed protection of those assets. Because then again, the whole thing of life policy is meant to take up that role of yours.
That's right.
You're now absent. You can't pay for the property. You need something that's guaranteed to cover for those debts. Can we trust our kids? Can we trust our families? Not so much when it comes to money. So it requires that people really hone into their own estates, understand their dynamics, understand their families as well. Right? I've seen a situation where families have gone after maybe one beneficiary of a life policy, trying to kill this person. You need to pay for these debts. We need to save this. This is that. But then the person is like, what's my involvement? This is my money. I'm not obligated to do anything. Often families don't understand. But the most important thing that was missing there was that estate plan, because that person would have understood prior to their death that it's a bit risky trusting your family members. So it requires a lot of planning and understanding your family dynamics and issues.
So please explain the whole process of ceding a policy to a bank with a view that if anything happens, then they will settle whatever you owe, like in the context of what you just said. Yeah.
Okay. So what you do is that instead of having a direct beneficiary, which is your child, you make it clear to the service provider that the funds of the life policy are going to settle by mortgage bond.
That's right.
That's with ABSA or whatever. You give them the details. And then what's going to happen is that instead of them paying to your son, obviously your son gets listed as the other beneficiary.
Yes.
So what's going to happen is that after your death, the claims will be made, but the money will not be paid to your child who's a beneficiary as well. It's going directly to ABSA or whatever bank. So the bank takes what is due to them. Then whatever's left, they will request for those details of that beneficiary. Then they're going to pay it over to that person. Exactly. So there's a guarantee.
Yes.
They don't have a choice. It started at the bank before it got to the actual beneficiary.
Yeah. All right. Now that we've got that out of the way, let's talk about this whole concept of generational wealth. Maybe we can start with the different types of instruments that could be used for generational wealth. Yeah.
Okay. So we've got things like businesses. We've got things like your stocks. Life policies as well can be utilized to achieve generational wealth. Now, with all of these things, for instance, that I've mentioned, in order for them to work, you're going to have to structure them to work for that purpose.
That's right.
Remember what we said about the life policy?
Yes.
You can't trust that it will last long now because it's going to one person.
Yes.
So, which means that you might have to sit down now and decide, what are we going to do with life policy? Who's going to be the beneficiary?
Yeah.
Because now we're taking away personal ownership or personal benefit so that this money can last.
That's right.
So now we look into things like your trusts. Look into maybe taking it to your estate, then eventually into a trust. Now, whatever it is that you're trying to do, you're trying to get it to an entity that will restrict access to this money so that it can last for a longer period of time and where possible, gets to the next generation and the next and the next.
Yeah.
So it's very critical. If you're going to use any type of wealth, you try and plan for it so that it can work for that generational wealth purpose.
Yeah. So I like what you said about you have to structure it. So I want to hone in on each one of them. So we're going to start with assets, for example, real estate or whatever the case may be. How would you structure assets in a way that could potentially create generational wealth? And what are the advantages and what are the legal restrictions or limitations of going that route in as part of structuring something around assets?
Okay. So I think the first thing would be to look into the assets that you have, immovable assets. Are you utilizing them to make money? If that is the case, already we need to take away personal ownership because we're taking away all of the risks that are associated with losing this property. So first option, why not put it into, let's say, a company? But then,
so basically taking the company, ensuring that the property, let's say it's a house, ensuring that it is owned by a company as opposed to it being in your name. Is that what you're saying?
Exactly.
Okay.
Taking away personal ownership so that if you die, you don't compromise these assets. So we're taking them, let's say, into a company. So they operate whatever business that they're operating under that company. But then again, there's still a risk if that business is in your name. Because after your death, we're still going to look into your shareholding, who's inheriting, wara, and all of those things. But then, if we were to leave it at that, that would be an issue. Because let's say your son inherits your your shares in that business. What's the likelihood of that business surviving? Zero. Next to nothing. Because they are probably not part of that business. And they don't even understand why you even have so many properties. They could start selling that business and it could just die. So now you look into the second aspect, which is taking ownership of that business away from you. Giving it to another entity. What type of entity? Why not a trust? A trust is an entity that has the ability to live eternally. Right? Depending on the terms and conditions. So if the shareholding is moved to the trust, what happens after your death? Nothing. It's as if nothing has happened because life continues.
And there's no account that's frozen there.
No account is frozen. People have access to money.
Yes.
Right? If you said after your death, let the monthly benefits go to my kids. After your death, we just obtain the death certificate, monies are distributed to kids. If kids need to go to school, nothing is held up.
Yeah.
We pay for transportation, we pay for school fees, we pay for necessities. So life goes on. So you want to look into such a structure if you're talking about, let's say, immovable property, so that at least it's safeguarded.
Yeah. I wanna take it one step higher. So here I have a house. I want to move the ownership away from me. So I then get the company to buy that property. So it's now in the name of the company, the business. But even the business itself, the owner of the business is a trust. I don't feature there. Is that what you're talking about moving ownership? Or should it be moved either via a company or can it move directly to a trust? And if it were the case, I mean, what would be the implications of moving that asset into a trust, which might be sitting on a zero balance?
So here's the thing. If you own, let's say, real estate property that makes money in a company, you know that at the end of the tax year period, we're only going to deal with a percentage of tax based on the income, right? And then minus whatever, expenses of this business. But now if you operate or use these properties to make money and you place them under a trust, you're going to need an accountant who's going to hone into the transactions of that entity, because the trust is it's taxed way differently. And there's 3 people that can actually be taxed in a trust. So it gets very complicated when you get to that stage. So often I say, might not necessarily be a good idea because the transaction could lead to the trust paying a lot in terms of taxes because there's a lot of income coming in, going out, and which means that there's more work to be done to account as to what exactly is happening in there. So just to take away that amount of big responsibility and the possibility of you ending up paying a lot in taxes, it might make sense to have the business, and then business is owned by the trust. When there's enough money in the business, it can always declare a dividend to the trust. The trust can then disperse to people like you and other beneficiaries some amount that you guys may need.
Okay. Let's say, for argument's sake, a business declares a dividend to the trust. What sort of tax comes into play there if it's owned by a trust?
So first things first, there's the dividends withholding tax.
Yes.
So obviously the company, as much as it would say, we're declaring 100,000 to the trust, 20,000 has to stay back and give the trust 80,000. Now, how that 80,000 ends up being taxed will depend on what happens in the trust. Practical example, 80,000 came in, we're still in the same tax year bracket. Then you decide, okay, 80,000 will be paid to beneficiaries directly. Then it's gone. There's not any money that's left there. The end of the tax year period, the people that received those monies will pay tax, not the trust.
At their hands, yes.
Exactly.
Okay.
So which means it takes away the responsibility of the trust being liable to pay for taxes.
Yes.
Because it went to certain people.
Yes.
So they will be responsible to make their own declarations to SARS.
Yes.
So then the trust is free from that.
Yeah.
So which makes it a bit lighter to deal with.
Yes.
But if you were to move now, all of these properties here, there's going to be a lot going on here.
Yeah.
You will need a lot of experts.
No, absolutely. Yeah. So I'm glad we're having this conversation, because for me, I wouldn't even say this is a creating generational wealth 101, because we're now honing into detail as to the mechanics behind ownership, which we've established early on, that to say ownership is overrated because it comes with other implications, but there's ways to manage it legally, right? So now that we've dealt with how you can structure assets as part of your generational wealth creation strategy, maybe let's go to intellectual property, for example. You might not be owning a movable property, but maybe you've got an IP. You have an intellectual property. You've got this trademark idea. It might be whatever the case may be. Maybe let's start there. What is an intellectual property, so that we don't assume that our viewers know what we're talking about?
So, in a nutshell, Jay, it's something that you have created out of your own mind. I forgot the actual definition, but it's something that you have come up with, you've created. So it's of your own intellect. Then you put it together. So you would call that intellectual property. A song that you come up with, lyrics that you write, right? An idea of how a product should look like. That's your intellectual property. You said there.
Hashtag.
You know?
Yes.
You said then you thought about it.
Yes.
So that's your intellectual property.
Yes.
Yeah.
Yes, because I know a guy. The name will come back. I mean, I know a guy who created a special walk, and it became famous. I mean, that's how people would refer to it. Man, but it was so catchy. That is his IP. But more often than not, people have an intellectual property, but they don't protect it. It might be maybe a TV idea. It might be a concept. I mean, let's look at somebody who, for example, who came up with a concept, I blew it. And they went to sell the idea, let's say, to, for example, multi-choice, and eventually we started seeing in our screen. Somebody had to own the idea. So other people have got great ideas on what sort of ideas. I'm just using the entertainment industry as an example. So you have an IP of an idea. How do you protect it? Because you can have it, and then if you don't protect it, then you can also be careless yourself, and somebody else can steal it. You have this IP, and you want to protect it for generational wealth. What do you do in that instance?
So let's make a typical example about, let's say, an idea of a show.
Oh, sorry, I remember that guy. He's called Bekele Beke.
Bekele Beke.
Yeah, Bekele Beke. Okay, so he has this walk. And, some people can create a T-shirt and call it Bekele Beke. But whose IP is that? It's that guy who invented that walk, Bekele Beke, and all that. I think it's an easy example for people to understand when we talk about an IP and owning an idea. So let's talk about, how do you protect it?
So very critical. You need to take the steps of registering that IP so that it is known that it belongs to you. That's going to be a patent or a trademark of some sort, so that the other people, when they get into the game, they are not able to utilize that which you have now protect, or you've come up with. So you now protected it. So I always say that first things first, before you talk to people about this idea, maybe find ways to protect it before then.
Yeah.
Because once you start talking to people, there's no guarantee that somebody else will not come up with it.
That's true.
Because all of a sudden you'll see another one saying, no, but I actually had this idea even before you came to me. But if you, for example, you had patented an idea, it's very difficult then for someone to say, no, this was mine. You're already registered.
Yes.
Yours is noticeable. You've got record of when it was registered. So it's difficult for someone to steal that idea. So when people don't take up such things, i.e. this Bekele Beke guy, another person can hone into it, run and get it registered on their own name. What can be done about it?
In fact, somebody can go and create a drink and call it Bekele Beke.
Exactly.
I know there's one artist that had this concept, Fill Up. And there were debates about it because other artists wanted to have their own gigs and they wanted to use the word Fill Up. But, if he has a trademark on it, then there's a problem if you use it. But I also know there are other people who found other ways. Instead of saying Fill Up, they say Gwalisa, what stadium.
Okay.
But essentially, it's about protecting that idea and trademark it in such a way that if anybody has to use it, they need to get your permission. And if they ask for your permission, you have a right to demand some kind of royalties for them for using that name and so on. So I think it's clear on that. Maybe let's look at another example of an asset. So there's stocks, for example, and cash. Maybe can you talk about those as well?
In terms of structuring them for generational wealth?
That's right.
For example, I know with stocks, a lot of the people who, let's say, who have this understanding that in the long run, these stocks are going to pay up, what they normally do is in their estate planning. Right now, the stocks might be in their possession. They could be benefiting from that. But they're going to make sure that when something happens to them, it is not benefited by anybody. In their will, they're going to have clauses that make it clear that as soon as I die, they are moved into a trust. Dividends are paid, they're paid into a trust. People will benefit directly from that trust. Because here's the thing. Let's say this person has these stocks that they bought and the company blows up. What's going to happen if they've died? Most likely, if they've left it to their children are going to be like, let's realize it.
Yeah.
It's sitting at its highest peak. But those stocks could have continued to work for that family for the longest. So always think about placing it in a trust so that they can't get access to it. They are restricted as to how much they can get. In your lifetime, it's fine. If you don't want to move it, you can deal with it. But after your death, make it a point they don't get access to it personally.
Yeah. So, for a lot of people who talk about creating generational wealth, but they don't have a will, what would you say to that? I mean, what are the dangers of attempting to create generational wealth and yet you have not structured a will? What are the risks?
There's no generational will there. Generational wealth that you're going to create. Because that's where you literally start with the planning, with the drafting of documents. And the will is very instrumental. For example, you could say you want to build generational wealth, but the things are still in your possession right now. So how are you planning on building this generational wealth without a will? Let's say in your lifetime, you are able to move only one property. What about the rest of them? So if you don't have a will, that idea of yours is not going to pan out. So as soon as you say generational wealth, the first thing is go do your estate plan. Go draft your will and then see if there's any other entity you're going to set up now or it's going to be set up at your death. Otherwise, if you're just saying it, it doesn't matter how much money you have. You will never attain generational wealth because we can't guarantee what the people will do with the money that they get. I.e. things like your pension fund. People often think that because I have millions, this is generational wealth. How? You leave a 25-year-old with 2 million, it's gone within 6 months. That's not generational wealth.
No, that's true. And I think maybe a caveat to that is a pension fund does not necessarily form part of your estate directly, in a sense that it is a law on its own, in a sense that there are beneficiaries there in a pension fund and the trustees are responsible for identifying them, confirming the beneficiaries and distributing the assets directly to the beneficiaries. Unless if a person was a worker and was contributing towards a retirement fund and they have no beneficiaries at all, then in that case, then it may bring that on this side of things. Maybe let's talk about if a person dies without a will. Explain to us the law of interstate succession act. How does it work in an instance where a person died without a will? I often hear people say, if you don't have a will, government. It will be chowed by the government. So maybe let's just demystify the myths. And at what point would anything like that happen?
Listen, it's most likely to happen, not necessarily for the government to spend, but it's most likely to end up at a place we call the Government Guardians Fund, because probably you're not aware of it. But what happens is that when you die interstate, right, we look at one, your status, and also do you have kids?
And just for the benefit, this is a lawyer we're talking about. When a lawyer says die interstate, you died without a will. So just to clarify.
Yeah, that's very helpful. So you died interstate, we're going to look at your status. Were you married? Were you not married? And did you have children? So in most instances, if you've got enough money or enough assets or you're worth a lot, both these parties should get. Right? And also we're going to look at the type of marriage you're in. Because remember, your party needs to get their 50%, and then we're going to deal with your 50. So if you don't have a will, automatically they are guaranteed 250,000 rand.
Yes.
Then whatever's left can go to the kids. But then there's also something we call a child share.
Yes.
If you've got no will. If let's say you only have one child and one spouse, and the money that you've left, which is your 50, let's say is 1 million.
Yes.
If you divide that by 2, how much is it? 500,000.
Yes.
So the law says instead of giving them or the spouse the 250, we're going to give them the child's share, which is that 1 million divided by 2, which is 500,000, because it's bigger.
Yes.
So which means your child and your spouse will get equal shares. But it's not as simple in most instances, because we have to hone in into the value that you've left behind. So there's no percentages that are often inherited. We can only determine a percentage after we've determined how much they're meant to get. So you'll hear sometimes people saying that when you die interstate and you're married, your spouse gets 75%, and there's no such thing. We have to look at how much, and we have to do these calculations. Once we've done the calculations, we can then determine, okay, this is the percentage. Then we start splitting things. So, but if you died single, only have children, your children are going to share everything that you have. Very simple.
Yeah. So I like how you're breaking it down there. But I think maybe for a more further breakdown. So when you die, you don't have a will. So the state dictates the process to be followed in terms of identifying potentially who should inherit, because you didn't tell us. So the government will decide for you where the money must go, and there's a formula that they use, and that's where you talk about the child share. Why should a spouse get a child share if she's not a child?
It's the law, right? It's the law has given. Listen, the law has given John, a lot of people the opportunity to draft wills, but they're not taking up this opportunity. So now, because there's nothing you've left or said, the law made a determination that, you know what, maybe they wanted the spouse to benefit even more. Let's just give the spouse a guaranteed 250. And if the child share is bigger, we're going to give them a child share. Because what's the reason of you not drafting your will?
That's right.
So unfortunately, the law, whenever, I think it's in 1960s or something, when they determined that, we were not here. So we don't even know what informed their decision making. So we just now following what the law states.
Let's say the person who died had lots of assets worth millions, and because they're an orphan, there's no one to bequeath these assets to, and they didn't have a will. What would happen in that instance?
So if a person is an orphan, we now start to look at further relationships. So remember, with you, because you had a spouse and a child, we could look into these two. If you, let's say you did not have a spouse, you did not have a child, would go up to your parents. They're the next in line.
So in this case, it's an orphan, there's no child.
There's no parents. So now we go to the siblings, like this, on dad's side, on mom's side. Then we're going to give those siblings whatever is due. But if there are no siblings, we then start looking at the closest relationship, uncles, aunts. Then those people in that line of relationship will have to share that amount of money. If we don't have these people, again, we're going to have to find someone who's closely related to this person. And if there's more than one person in this line of whoever it is that we find, they're going to share what that orphan left behind. So that's why it can get a bit complicated, because we need to start looking at relationships. How far are they to this person? And then we give them what is left behind.
This is why people inherit relatives when they die. Relatives that they never even spoke to when they died. So let's talk about the tax regime that applies when it comes to deceased estate, because people don't know that when you die, you are regarded to be someone who's on their way to SARS, but something happened along the way. How much will the state take from your deceased estate when you die?
So it will depend on, one, your affairs at SARS. There are some people who don't declare. And death will reveal everything to SARS. Also, because you've died, we're looking at, let's say if you had immovable properties, we're looking at now capital gains tax. because as soon as a property has to move from you to another, it's regarded as a sale for purposes of tax.
Yes.
So looking at that.
What percentage is that are we looking at?
We also have to calculate that. There's a formula for that.
Okay.
Then it gets determined. And then we also have things like your, what is this tax? It's called, it's like 20% of your net worth is taken away if you're valued at more than 3.5 million rand. It's called estate duty tax.
Yes, estate duty.
That's the most expensive one.
Yeah.
So that also has to be calculated. It's based on how much you've left behind.
Yes.
Guaranteed, if your assets or your estate was more than 3.5 million rand, it will be charged by SARS. What other taxes? But the most important thing is that you need to know this. You need to sit down with someone, because during estate plan, we can already determine possible taxes that may be applicable here. That will also inform you going forward. Should I be keeping these things in my personal capacity? Or is it time for me to remove them away from me because they're going to be very expensive?
They will attract tax even when you die.
Exactly.
Yeah.
So every time before we finalize a deceased estate, it goes to SARS.
Yeah.
They have an opportunity to look at everything. Then they're going to determine, okay, so-and-so owed us this much.
Yeah.
Probably before they passed away, or they had not declared during their lifetime.
Yes.
And now there's also these death taxes. Then they're going to say, you owe us this amount.
Yeah.
We've got to settle that amount in cash.
Yeah.
SARS has got nothing to do with your properties.
Yeah.
They want their money in cash.
Yeah.
Which is why an estate plan is important, because you make provision for this money.
Yeah.
Because if there's no money, we start selling things so that SARS can get their money.
Yeah. I think it's so important to talk about this, because people think it's easy to just, I'm going to generate generational wealth. And this is why it's important to demystify it, that there has to be a concerted action. There has to be a plan. You must be intentional about structuring something for generational wealth. It won't happen in its own. And just because you've got that access doesn't mean you are creating generational wealth. There are specific things you need to do. That's why it's important to speak to a financial advisor, your lawyer, to structure these assets or instruments that you have for generational wealth. Now, the other thing I want us to talk about is the difference between, when it comes to an estate, a deceased estate, letter of authority and letter of executor. What's the difference between the two?
Okay. So, letter of authority, you are valued at less than 250,000 rand at your death.
Yes.
So it means we're not going further. We're not going to do anything beyond reporting to the master's office.
Yes.
That's the only letter that you need. But now, if at the time of your death, you are valued at more than 250,000,
yes,
you're going to, or your estate will be issued letters of executorship.
Yes.
So these letters will allow the executor to be able to communicate with different institutions, the banks, etc. Right? But then there's a lot that needs to be done after the letter has been issued now. We do advertisements for creditors. We do them again.
Yes.
We draft liquidation and distribution accounts because people need to see, am I there? Did they consider the fact that that one was owing me money? Because I need to be on that list.
Yes.
So all of these things have to be advertised, and they take, let's say the first advert takes about a month. The next one has to take about 21 days. And approval has to be given at the master. So once you are at that wavelength of more than 250,000 rand, you can expect that your estate will go through the administration process for something like a year or so.
Yes.
Before anything can move to your beneficiaries.
Yes.
Yep.
Now that we've explained that process and we've elaborated on it, I think this is the best time to now show the difference between winding up a deceased estate and the admin and the tax implications that comes with it versus having your assets owned by a trust. Are all these processes applicable when all these assets are owned by a trust?
No, they are not applicable. Remember what we said at the beginning, that let's say we move our assets into this company ends up being owned by the trust. Once you die and you had a trust, the structure was in existence. It's like nothing happened to you. Unless, of course, there were certain conditions now that apply to the trust. Because sometimes after your death as the person who founded this trust. There would be terms that have to now be different. But that's it. The trust will continue to be administered. It's not really affected. You're just gone. The kids or whoever you're leaving behind, they're just heartbroken, but we move on.
Yeah.
Now, when it comes to the administration aspect of it, if you did not move your things into a trust, that's a different story.
Yeah.
One, whatever amounts of money that you left behind, they cannot be accessed because we're still dealing with the administration.
That's right.
Because it's very risky for us to be giving money out, whereas we're still not certain if the creditors will get what is due to them.
That's right.
Because the law says first things first.
Yes.
Who's important? Creditors.
That's right.
So monies are held tight. Properties cannot be transferred.
Yes.
There's only one person who rules over these properties, and it's the executor.
Yes.
And often, sometimes these executors can do their own malicious things.
Yeah.
So it's totally different.
Yes.
Administration and having a trust is much more beneficial.
Yeah.
And plus, with the administration, you still have a lot of uncertainties. More debtors or creditors, rather, can come through.
Yeah.
More taxes could be imposed because you decided to go through the administration process. So where possible, it's always nice for people to consider the looking into a trust, because it could save them a lot and their families a lot, in fact.
Yeah. Wow. Sure. I think this is a lot for one person to consume at the go. It requires one to listen up and reflect on this, because creating generational wealth comes with a lot of work and a necessary work that needs to be done upfront. But maybe your parting shots, talking about generational wealth, what are the top maybe 3 things that you think anybody who intends to create generational wealth should be doing from a foundational point of view? What should we be doing?
First things first, I say build the wealth. Where is it? It's a business, you must be building it. Because when you're saying you're leaving wealth, meaning you're leaving money that can help your children get a head start, your children's children. So build that. Find something that you can hone into and make money from. Number 2, you have to structure it. What's going to happen to it if you're very sick? You have to put certain things in practice here. I.e., we've got things like your key man insurances. For people who are building this wealth, you might get sick. You need something that's going to keep that business running.
That's right.
Prior to your death. Then you also need to have death care plans. What's going to happen then at your death? If you were the director, who takes over? Right? If you did not move, let's say, the shares during your lifetime, now if you're moving them, who's going to be running this entity, which is the trust? Because the idea is that you move it to an entity so that it can be generational. Who are the trustees? Do they have an idea of how a trust is run? Can they even run a business? Can they be able to find someone who has the expertise? So these are the things that you just need to think about if you're saying you want to leave generational wealth.
This is where I think people also might be missing it, that some of the wealthy people around the world, they take these life covers and they know that should anything happen to them, if they've created a trust and the trust is the beneficiary, when a life cover pays, it pays into that trust. And because there's no tax when it comes to a life cover, the trust is funded. And then that creates more wealth for the next generation and the next generation and the next generation. But again, it just highlights what we've been talking about, that you have to plan it, you have to structure it, but you need to speak to the right expert to get there. Well, Yolanda, thank you very much for joining us. I think this was such a mind-blowing conversation, particularly on this subject, which I think there isn't really a lot of talks around these kind of topics, and people just throw in words without understanding what they mean. I'm hoping that our viewers would have learned something and they will see a need to speak to the experts and to get help that they need to generate generational wealth.
We can only hope, John.
Yeah,
we can only hope.
Where do people find you if they saying, well, hey, I've had this, but you know what? I need to speak to somebody. I need to know, how do I create this trust? I need to know, of course, then I'm sure you would refer them to the relevant institution to speak to a financial advisor. if they need to take a life insurance in relation to some of the stuff we spoke about, where do people find you?
Okay, so they can find us. They search us online. They'll find our website.
Yeah.
We're also on Facebook,
Yeah.
Mnyengeza_attorneys.
Yeah.
We're also on YouTube,
Yeah.
and we're also on TikTok.
Yeah.
So if they go there, they will be able to find our details there.
Yeah.
And then they can be able to get in touch with us.
Okay.
Yes.
Thank you for joining us.
Thank you for having me.
All right. Huh. Yeah. Okay, go and create generational wealth. That's all I can say.